Connors,
Present.
Member Jackaloni, Member Reposa,
Present.
Member Director McGill,
Present.
Legal Counsel Brandon Carter.
Present.
Thank you.
The first item of business, the board may hear and vote upon any appeals from the local board of canvassers' decisions regarding challenges and objections to the eligibility of candidacy or sufficiency of nomination papers pursuant to Chapters 7 and 14 of Title 17 of the general laws, including the following candidates: Omar Reyes, Pawtucket School Committee, Democrat; Angelise Rosa, Pawtucket School Committee, Democrat; Anna Borges, Mayor of Pawtucket, Independent; and Arlette Hidalgo, State Representative, District 12, Democrat. I will first turn it over to the Executive Director and then to our legal counsel.
Thank you, Vice Chair. I believe that legal counsel Brandon Carter has had this opportunity.
Yeah,
Right.
thank you. Thank you. Before we hear from the parties, including from the petitioner in the first case with Mr. Fargnoli, I did want to first note that there may be a recusal.
Yes. From the first person, Omar Reyes, so I will step out from the
So
discussion.
let the record reflect that Commissioner Bettencourt is recusing from the first item of business, which is Omar Reyes.
So the first matter does involve an appeal by Mr. David Fargnoli, who is here at the table, from a decision by the Pawtucket Canvassing Authority concerning both candidates Omar Reyes and Angelise Rosa. I will allow Mr. Fargnoli, after I get done, to clarify anything I say that I may have misstated or to add any further argument that he wishes to make. But there are several legal issues that I thought we should first have in mind that might frame the hearing itself. Mr. Fargnoli asserts that he signed nomination papers on behalf of Mr. Omar Reyes on nomination paper 6, but that a Ms. Angelise Rosa signed the certification by affidavit that Mr. Fargnoli signed the nomination in her presence. Mr. Fargnoli asked the board to disqualify the nomination papers that include a certification affidavit by Ms. Rosa on any of those affidavits, contending that she improperly certified that she witnessed the endorser's signatures in her presence. He contends that all nomination papers that were certified by Ms. Rosa are suspect and everyone should be rejected. He further seeks the removal of both candidates, Mr. Reyes and Ms. Rosa, as candidates in the 2026 election cycle due to his claim of fraudulent misconduct. So assuming just for the moment that the petitioner is able to establish with evidence each of his claims, the question becomes what would be the remedy available to the board? Namely, should nomination papers that have been improperly certified be stricken in their entirety, or should just the signatures that weren't properly noticed or witnessed be stricken? The Rhode Island Supreme Court addressed this issue, finding that only the invalid or forged signatures are to be discounted, and that if a sufficient number of valid signatures remain, the nomination would still be valid. The court refused to invalidate all signatures on the nomination papers merely because of the false attestation, ruling instead that only those signatures not actually witnessed should be invalidated. As the court stated, the clear import of these statutes is that only the invalid or forged signatures are to be discounted. If a sufficient number of valid signatures remain, the nomination is valid. I also want to just note that we do have a doctrine of mootness as well. If the board's decision cannot change the outcome of a dispute, the matter would be considered moot. We have spoken about that before, and if it becomes relevant, I can give more details on that. I should also note that Mr. Farnioli filed a separate filing, which appears to be after the deadline for doing so, but I believe Mr. Farnioli has a different view on that and can explain that to the board. But our Supreme Court has said that the filing deadline for these challenges is mandatory. This board has no discretion to ignore that. Otherwise, challenges could keep occurring and refiled or be filed after the deadline, giving no finality to the nomination process. So those are the main things I wanted to address first with respect to the challenge brought by Mr. Farnioli.
So Ray, as I understand the case law that you presented with regard to any additional signatures that someone might be seeking to invalidate, they would need to do those on a signature by signature basis. Is that?
Every signature needs to be assessed.
Correct.
And determined to be valid or invalid. Unless, for example, and this has happened in some case law, where the person who did the affidavit says, every single signature I did was done outside of my presence, well, then that would invalidate every single one of them. Here, at least as I understand it, we have one signature that Mr. Farnioli himself penned on the nomination papers, and then he saw that someone else had certified it as opposed to the candidate himself, when he's claiming that the candidate is the one who actually witnessed his signature.
And factually, how many signatures are involved? Just so that we can put that on the record, how many signatures were validated at the lower level? If you know.
I can get your information. If you want to review the signatures specifically.
No.
I can tell you that the candidate has sufficient signatures, despite the fact that the local board disqualified that entire page. The candidates both have enough signatures to qualify for the ballot regardless.
So from that standpoint, Ray, would mootness be an issue?
It very well could be, because if you have an insufficient number of signatures that could change the outcome of this process, this challenge, then anything you do would make no difference. So typically, a court would not render a decision when to do so would afford no remedy to the parties.
Thank you. Should we hear from?
Yes, and I think, Mr. Farnioli, I know you're going to be presenting argument, but it seems likely you're going to be presenting facts, so we're going to have you sworn in. Is that all right?
So-
And we should make sure your microphone is on. Just press it down for a few seconds. There it goes.
That's it. It's on. It's green. So, Mr. Fagnoli, would you raise your right hand, please? Do you swear the testimony before this board will be the truth, the whole truth, and nothing but the truth?
Absolutely.
You can begin your presentation.
Okay. To go at the solicitor's point, respect the Supreme Court's decision. So we're going to take this in a little bit different of a direction. Seeing as Ms. Rosa has already been found to sign the back of a document affidavit, which states she received every signature on it, her signature should be moot. It should not be counted, which means every affidavit that she signed the back of should be disqualified. Because if she signed one fraudulently, how do we know she didn't sign all of them fraudulently? We don't. So I think that the Supreme Court's decision really doesn't apply, because this is an oddity of a case. We're looking to disqualify pages because they were signed by someone who fraudulently signed one that is admitted so at this point. So I don't believe this is a moot point in any way, shape, or form.
But do you have any evidence of any fraudulent activity concerning Ms. Rosa that was part of your original petition?
Yes, to the Board of Elections or to the Board of Canvassers?
Well, we're here on appeal, so it would have been to the Board of Canvassers. They
Well-
would have needed to address
Well,
this.
what we have to do is go off of the Board of Canvassers' opinion in their minutes. If you wish to change the striking of the whole page and just strike the one signature, You also have to understand that there's discovery time for me to come and put a complaint in here so that we can sit here today and I can be in the audience of you. At that time, I have discovered multiple sheets, and I have emailed Mr. Nunez with those sheets that I have concerns with, not only the signatures on the back of them, the timestamps on the back of them being exactly the same, all of those things, that being the form in which was found to be fraudulent by the Board of Canvassers, turned in at 8:41 of the 9th, all 4 pages. 2 for Mr. Omar Reyes, 2 for Miss Angelisa Rosa. Miss Angelisa Rosa signed all 4 of them. So now I believe we've just opened up a reason to continue here today. So what I'm saying is, if she missigned one and she turned 4 forms in at the exact same time to the Board of Canvassers on the 9th at 8:41, we're showing a pattern here. And
But
that
you,
pattern will continue to be shown as we move forward.
but you do have the burden of proof, both before the local board as well as to this board, to show
Well,
that there's some
I
evidence of fraud.
satisfied the local board. You're here to modify or that hearing or that decision or those minutes that they had.
Okay.
I am here upon being a candidate. I have every right to file this appeal to the objection and the challenge. I put in more than sufficient enough evidence to the board in plenty of time on the 17th, which was the deadline for information, even emailing in multiple addendums to that, which covers more than what the board would need to look at. The burden of proof is not mine, it is mine, but it's been provided.
Do the board members have any questions of the petitioner?
If I could just answer the vice chair's question. So Omar Regis has 217 signatures, and 200 are needed to qualify for the ballot. And Rosa has 215 signatures, and 200 are required to be on the ballot. I don't know if anyone from Omar Regis's campaign or Angelisa's here as well. You might want to hear from them as well, since they're the respondents to the objection.
As soon as Mr. Fognoli, are you finished with your presentation?
I'm not finished with the full. If you're going to hear my full presentation, that was my statement to the objection of mootness.
We'll give you the opportunity to present whatever evidence you want to present in support of your objection.
Absolutely. All right.
With
In support of your objection, was there a section objection made today?
There was an objection that was filed on or about July 17. Is
You
that
have
right?
copies of that.
It is, do I have the date correct?
Yes, on Monday.
So that was about 4 days after the,
17th was Friday. Monday was the
20th.
20th.
so
That's
that,
when the extra thing that Mr. Nunez is speaking of. That's why I thought
Yeah.
that email chain would be very important for you all to have, so you can see exactly when the communications came through for all of the addendums, the 2 addendums that went in before the deadline. And then, yes, when I found altered fraudulent documents, nomination documents, you bet your behind I called the Board of Election and told them about it.
yeah.
And
So-
the Board of Elections would look at
First of all,
pages
Mr.
6.
Fognoli,
Yes.
first of all, I'm going to caution you as to the use of the word fraudulent. I would prefer you use the word mistaken or erroneous, because your characterization of fraud becomes a criminal matter, and those items you're free to go to the Attorney General with. But I just want to, just let me finish.
Mhm.
So I want to caution you on your use of the term fraud. I know it's a hot button issue. Fraud needs to be proven,
Mhm.
and any proof you have of fraud, you can certainly bring that to us. But to simply characterize something, I'm not going to allow that. Stop, I'm not done yet. I'm not finished yet. Okay. So secondly, any items that are beyond the statutory period, beyond that initial period of claim, I don't believe the board can hear today. Am I correct, Ray, or not?
That's right. The court has said that the deadlines set by statute must be complied with.
And
So-
that's,
So the
That's-
local board has had no information on this whatsoever. The local board has heard nothing on this.
Okay, I would ask the board to please look at Omar Reyes's forms 6 and 7,
6 and 7?
please.
Okay, we'll start with 6. Is it 6 line 16 that your concern is?
No, it's the reverse of the forms on form number 7,
On form number 7.
correct. To see that on form number 6, you have the form number box on the backside. And on form number 7, you do not have the form number box on the backside, which makes this an altered or erroneous document. And if it would please the board, that's the one that's in file, but the petitioner has many more of the same style forms.
So tell me specifically, I'm looking at form number 7
Correct.
on the reverse side. What specifically is your objection on form number 7?
There is no form number box on the back side of it. I have nomination papers from the last 3 elections that I received nomination paper, signatures for, that have boxes on the back and the front, so that they know what form it is, so that there can be no erroneous activity or anything to that effect. And these forms that I have discovered do not. I would never suggest to tell the board how to handle situations like this, but the candidate number that's on the front is so important to be on the back side as well.
Did you raise this with the local board to address it?
The local board was aware of this.
That wasn't his question.
What's that?
That wasn't his question.
Was this addressed by did you present this to the local board as part of your
No,
challenge?
this was part of the discovery to
Okay.
come here.
See, our problem is that we need to make sure that we have a record from what was done below, that we then review as the reviewing body of the local board decision. I can fully understand that the deadline is super fast for you to submit your papers, but it is the deadline that we follow. So the record should be, and the focus of this board should be, whatever was given to, reviewed by, and decided by the local board, that comes up as part of your, as you said, your appeal. We then review that.
I was informed when I came in that this was actually, couldn't be considered an appeal. It would have to be a challenge complaint moved forward to the board, because I did not agree with the board's finding. So that's my standing by this. Is I was told when I put in the complaint that this was me moving forward because I was not satisfied with the board's decision, the Board of Canvass's decision. This is not the question of, as far as I understand the law, of the signatures being challenged falls upon the petitioner, which is I.
That's right.
Now, there is a deadline to get my evidence in here. Now, you're welcome, it states by law, to review any challenges that come up through. I was actually informed that it's very rare that the board changes a decision from a Board of Canvass's as far as their decision is concerned, unless there is additional evidence to add, which is when I added all of this additional evidence to this complaint. So I think what your argument is that mute to hear in front of the Board of Canvassers, this isn't going to go away, guys.
So to the board, I'll just say that this board and the local board have full jurisdiction at any time whatsoever to review, assess, decide whether anybody involved in the election process has committed fraud, misconduct, or any other error that might be necessary to be reviewed to make sure that the election process is fair. That's extremely broad. What we're talking about for today is the rapid fire review and assessment and decisions on papers submitted by signatories, endorsers for a nomination. That's all that's before us right now. Are there enough valid endorsers to then advance this to the next step? That has to be done extremely quickly because of the federal laws that require that the mail ballots, the ballots be sent out overseas. And for people who are involved in the election process, who are investing money and time to know that they can then proceed with their candidacy. So the deadlines that we're talking about here, namely on or about July 13, the director can correct me if I'm wrong on the canvassing authority deadline, that is a full stop with respect to the nomination papers that are going to be reviewed to see if there are sufficient numbers. If they're stricken because of the address or any other reason, in that time frame, you look at which ones are valid, and then you either advance the nomination or you don't make it, right? Any claims outside of that can still be reviewed by the board, but not in this forum. This is to see whether or not the nomination papers have adequate signatures under that very tight deadline. So that's why the court, even in, for example, the CNC web case from years ago, where a challenge was made well after the nomination submission, and the court said that that nomination submission found under Chapter 14 of Title 17 is something that cannot be ignored, and it has to be followed. All we're doing today is ruling on the nomination papers signatures to see if there are sufficient numbers. If you have a, I'm not suggesting that you're establishing fraud, I'm not suggesting you're not. If you have a claim of fraud, that can be reviewed by the local board at any time, but it's not done in this forum. And that's what I'm just trying to make sure that the board is aware of. So if you have additional papers you want to submit, Mr. Fargnoli, they're out of time for this nomination paper process. That's all I'm saying.
I understand what you're saying. But by law, this is the forum that I was given to come and bring this. I brought a regular complaint, and I was told it was the wrong complaint form and that I needed to go by this form. I brought in a regular complaint form so that I could sit in front of this board and have a proper hearing.
Yeah.
With 20 days to respond and to get my evidence over.
Right.
All right? I had that form.
Yeah.
I was told that was the incorrect form.
That regulation applies. That is, you're talking about the regular regulation on appeals, and it does afford somebody 20 days from any decision they wish to appeal from. Again, that falls well outside of what we're talking about. That regulation yields to the clear statute that says you must make decisions within a day, within 2 days, and for reasons that the General Assembly has made clear to us. So that's what we're talking
But the
about.
Board of Canvassers is also supposed to do an investigation into the claims that go in.
I can't speak to what the local board has done or will do with respect to any of the allegations you've made. That's really for another day, if ever. I have no knowledge on that whatsoever. I'm just saying from a legal perspective, we're here today to talk about what you challenged before the local board, why you think what they did was inappropriate, incorrect. This board will then make a decision as to whether they agree with that. That's what's before us. Adding additional claims of fraud, misstatements, misconduct after the local board has seen it, again, that's not part of the very rapid process in place under Chapter 14 of Title
I
17.
think that, and with all due respect, I think we're looking for a loophole where the evidence is sitting right in front of us right at the moment. This was the forum I was given to come and bring this evidence to. And I understand you're saying the Board of Canvassers made a decision to strip the whole page. Now, you're speaking to a particular signature. Now, I personally can speak to a person committing perjury at that Board of Canvassers because I watched him collect multiple signatures while I was there and signed my name to it. So the board decided to strip all the signatures. So of course, I'm not going to question any of the other signatures that are on there because they had stripped them all, period. You've got to understand the petitioner's side of this. I went through the process exactly the way it's put forward. And here I am, you know. I was told I could add extra evidence to put in here.
Regardless of what you were told, sir. Regardless
From
of
your
what you were told.
administration.
I will just state that I did not tell them that to him, so.
Look, we've had these nomination paper issues they've been here for years before I sat on this board. The deadlines, as our legal counsel is trying to tell you, are strict deadlines. We are mandated by statute to follow those deadlines. You have other areas in which you can pursue this. It's just not here.
This is the only forum that can take care of the election integrity of this state.
And everybody on this dais agrees with you. It's just that review does not take place regarding the challenges to signatures. So for example, under what you're saying, we could make a decision today. You could go home and over dinner realize that there's additional information you could have provided, file another supplement. This board would then have to be convened to hear further signatures. It doesn't, for better or worse, it just doesn't work that way.
Which is why myself, the petitioner, is not looking at the signatures here. I'm looking at the signatures here.
All right.
The ones that were done by someone who has already admitted to signing an affidavit fraudulently. And that's not the document, that's the individual.
All right.
So if
Do you
the
have
board
any-
is comfortable with
Yeah.
allowing someone who's admit to fraud stay on the ballot, and two incumbent members of a school committee that know the rules. There's no excuse for this. This is not their first time.
Mr. Farnioli, if you look at the history of this board, you will see that there have been times when this board has been involved in removing candidates well after the nomination. Again, what we're here today to talk about, though, is the nomination, not whether there's some evidence that you may present to the board that investigates, or to the local board that investigates, or to the attorney general. All that is not being decided here. Those are your allegations. I get that. We just have to, we're here to quantify the valid signatures versus the invalid, and to hear from you whether the ones that were invalidated or validated by the local board were made in error. That's why we're here. And is the city canvassing authority here as well? Do we have, and by that, I just wanted to make sure, do we have on the record, do we have a full record of the papers that were part of the Pawtucket Canvassing Authority? We should mark those as Exhibit 1. Mr. Farnioli's initial objection to this board should be Exhibit 2. The supplemental objection that was filed on or about July 17 should be Exhibit 3. But I just want to make sure we have a record on that, and I can go over that with Talia after, but we should make sure we have that on the, just in case there's any review of any of this. Before we get to the city canvassing authority, is there any other questioning that the board has for the petitioner?
Any questions from board members?
And I don't know if there are any questions for the canvassing authority, but I thought that you should be at least be heard from if there are any questions. And are the other parties here, the other candidates?
The candidates are here.
They are here. And you certainly have an opportunity to be heard as well. It looks like we have no questions for you, so, okay. And what we should do is swear in both of them.
I'll ask you both to raise your right hand. You swear the testimony you give before this board is the truth, the whole truth, and nothing but the truth? So help you God? Thank you.
If I may, first, I would like to thank you for your service and for your commitment to free and fair elections. I just wanted to clarify
And
something.
I'm sorry, would you identify yourself as well?
My name is Omar Reyes. I'm a candidate for school committee for reelection. This is when I introduce yourself.
I'm Angelise Rosa, candidate as well too for the school committee.
So I just wanted to clarify something and also ask a question. So on July 15th, was last Wednesday, I believe, was a day in which we were at a city council meeting, ironically, to oppose our city council trying to change their charter to make a mostly appointed school board. And on that day, Ms. Rosa and myself were collecting signatures side by side in the same room. So, we collected all the signatures were in that room, so we collected the signatures. She's in my presence. The next day, I was supposed to be heading to DC for a conference really early. And so I sat in the back to make sure that everything was filled out correctly on my nomination papers, to which point Mr. Fargnoli was behind me. Ms. Rosa was maybe like 15 feet ahead in the same room. I remember waving at Ms. Rosa saying, "Oh, get your signature collected from Mr. Fargnoli." So he essentially, he must have heard me say that I was going to go to DC the next morning. And that's why he offered to sign my signature, in which he collected the signature. And Jaleesa and I looked at the back. She was like, "Oh, you need to sign it." I said, "I can't sign it because it needs to be notarized." And we read the paper. We read the back of the nomination paper where it says, "I, blank, of the city town of blank, under oath, make affidavit and say that the signers of the within recall petition did so sign the paper in my presence. In my opinion, she was in eyesight at all times. That would mean that it was in my presence. If I misunderstood that was a simple, that must have been a simple mistake, but the form says in my presence, and that's very, as a newer candidate, that is very much left up to interpretation. When we went to the Board of Canvassers, they struck all the signatures, which, because I already had enough signatures, I didn't contest it. And I said, okay, it looks like I made a mistake, not understanding and not realizing that presence versus witnessing somebody sign a signature. I could have somebody give somebody my nomination paper and have them sign it and look the other way, and they're still signing. That I hadn't witnessed, technically I didn't witness them signing the signature itself, but I was in their presence doing that. And so Ms. Rosa agreed to deliver my papers in the morning, and that is essentially what happened. That to me would qualify as presence. I'm grateful that, Mr. Vice Chairman, that you clarify what fraud is, because that's really hurtful to me. We try to run an election, do something good for the kids, focus, my career, and risk my career, and then you have people make accusations like that it seemed like the signature, him giving me the signature itself, was probably the most egregious act of fraud, because he knew that he was going to contest it. And that, to me, feels really disingenuous as to what we're trying to do here.
And then if I can just add is that Mr. Fagnoli is very much aware that when Mr. Reyes was collecting the signatures, he was side by side. But again, it was very much of a, "Oh, hey there, David." And, you saw me, we saw each other. We saw that you signed the paper. He also signed my nomination papers when it was just him and I. But I think it's open to interpretation about the present, because again, we were in the same room and in the exact same presence of each other.
you have a response?
My response is, Ms. Rosa collected my signature in City Hall outside of the clerk's office, not at the city council meeting.
That is true.
Yes, that is true. Mhm. Also, Mr. Reyes just said papers, plural. Mr. Reyes also said he did not contest the decision by the BOC. So I don't see where the Board of Elections is looking to strike that when they did not challenge it. You're taking,
No, I don't think that the board is. I mean, if there was a challenge, I would be advising my board that the local board may have gone too far in the remedy, because what should be stricken is the offending signature, not the entire paper, the offending signature. Now, there could be cases where all the signatures were supposedly, there is a case where over 100 signatures were claimed to be signed by the affiant when they weren't. Those should all be stricken. But here,
she signed a paper that she didn't receive all the.
okay,
So that means that sheet should be
all right.
completely
And
stripped.
Mr. Farnell, we're not here to argue with you, but really, your burden is your burden, and that's going to be up to the board to decide.
You do agree that the local board struck the entire document, correct?
They did. Yeah, there's
And
no-
you also agree that even with that document stricken, they have enough signatures to be put on the
I also
ballot?
agree that there was 4 pages stamped and signed by Ms. Rosa on the same
Tho-
day.
Were those pages contested at the lower board?
The pages, you don't get, all right, so if we're
I'm
gonna,
just
if we
asking
wanna
a
go
simple
into
question,
that,
sir.
we were given till Monday, the signatures were due on Friday. We were given till Monday at 4 o'clock to put in a challenge and to gather your information. Your objection had to be in by that day, which means you can only go and gather your information.
I
and
don't-
your-
I don't think anyone here is saying that it's not a short time period. Our legal counsel specifically addressed that it's a short time period, and it's a short time period because that's what the legislature wanted. And the court, and just let me finish, and the court has indicated that those time periods are not extendable by this board or anyone else, quite frankly.
Then what is the extent of?
I've had separate matters that I filed in the Superior Court before I was a member of this board. And the Superior Court decided that even it did not have the ability to extend that time frame.
Then what is the purpose of the appeal process up to the Board of Elections?
To appeal the decision of the Board of Canvassers, which we are reviewing right now. Do
Usually
you have anything else with respect to the challenge that you issued on the 13th?
All of
And
this
so-
is
so present-
pertinent.
So tell us what your specific challenges are.
My challenge is that page 7 that was in the original is just one of multiple phony documents that were turned in throughout here. I mean, I find one, and honestly, I go through here, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20 phony nomination papers.
This is form number 6?
Hmm?
What form are you looking
I
at?
am looking at form number 6 is followed by form number 7 of Mr. Reyes's.
May I say something quickly?
Well, form number 6 is the form that was stricken, is it not?
Yes.
That's right.
Correct?
Mhm,
Okay,
yes.
so you're happy with the fact that that was stricken, correct?
I'm happy with the fact that was stricken, but I also told them that I was bringing this decision forward to the board because the board at its discretion, nothing within the board's discretion stops them from removing a candidate upon their own discretion.
We did discuss that. I did say that. That is not part of this rapid-fire review of local board decisions, but this board certainly has the authority to investigate and to remove anyone who has committed an improper act. That's true.
So.
Not that I'm suggesting that it's occurred here, but this board has that jurisdiction.
The board, yes, they can hear any arguments upon that, yes.
Yeah.
So,
That's-
Mr. Fognoli, if I look at form number 7
Yes.
and I turn it over, your objection to this form is that it doesn't have the box that says form number in the top left-hand corner. Is that correct?
Yes.
Okay. And are you aware that these documents are allowed to be copied? Are you aware of that?
I have copies of all of my
No.
nominations.
The blank documents, are you aware of the fact that they're allowed to be copied?
The blank documents?
Correct. When you go get signatures.
You're gonna have to catch up with me there.
So
Blank copy.
I'll actually direct this to our legal counsel. Are these documents, these nomination forms, are they permitted to be copied by the candidates?
I can answer that. Yes, they are. They can be reproduced by the local board of canvassers, the blank ones, or they're allowed to be copied by the candidate. So potentially, they could have cut off the form number. The form number that's on the back is for the processing of the board of canvassers, so they can keep track of each form number, but they're not a required field for the candidate on the back of the form.
And Miguel,
Thank you,
is there a stamp or something else that's put on the copy?
In previous years, that was the case, but that practice ended several years ago.
May I say something? I just wanted to also, when people say defamatory things on the record to try to get their 10 minutes of fame, I just want to point out the irony that Mr. Fagnoli is contesting my signatures on a procedural thing and then wants the board to make an exception on a procedural thing for him because it's okay. And I would just like to point that out for the record, that exceptions, I took ownership over the fact that procedurally during the Board of Canvassers, maybe it was borderline. And I said, okay, I made a mistake because that is what a person with responsibility and honor does and integrity. But then he wants you all to make an exception on the deadline for processing something else. I just wanted to point that out.
So, Mr. Fagnoli, your objection to these forms, you're objecting to any form that doesn't have that box in the top left-hand corner on the reverse side. Is that correct?
I am, yeah.
And that's your substantial objection to these
Oh,
documents?
to all of these forms, because it's altering an official document. Honestly, if I could make a suggestion to the board, you should put candidate numbers on the backside as well.
Mr. Chair. I do want to point out that the objection with regards to the box on the back of the forms is the one that came in late. So I don't think this board even has the right to listen to that.
Could not agree more.
The first objection is simply the appeal to the Board of Canvassers' decision to strike Form 6, which seemed appropriate. So I just didn't want to go off on the board discussing the boxes on the back of the forms because it was filed late.
I understand. I just wanted to clarify what he was actually saying, because I wasn't certain at first, but now that he said that.
And for Board Member Connors and Vice Chair, I also want to be clear that the original objection that he filed with the Board of Canvassers only included form number 6. It did not include the additional forms that he submitted to me on Monday, 2 days after the deadline. So the original submission to the Board of Canvassers only contained form number 6, which was stricken by the local board.
So, Ray, it appears to me he was successful in striking that form at the lower board.
On that he's now seeking other relief, but yes, on that he was.
We have no evidence of
I'm sorry.
objection to other forms that's presented here. But Mr. Fignoli, I have a question. This seems to be a bit off the whole thing.
Okay.
You are running for school committee along with Mr. Reyes, right?
It has nothing to do with.
Yeah, but why would you sign his nomination papers?
Because I'm a nice guy, because I sign everybody's nomination papers.
So you're
I
a nice,
signed Miss Angelisa Rose's as well.
so you're a nice guy coming here objecting to them?
To a.
How's that a
to
nice
What
guy?
I would say, integrity of election, and those who represent us. You can look at me as if it doesn't matter. This is irrelevant. This is huge. You think it's going to end here, guys? This is humongous.
But I've been in politics too, but I don't sign my opponent's nomination
Well, in
papers
Pawtucket,
and
we
then
do.
come over and object that you get the wrong signature.
No,
That is,
no.
seems to be a bit odd.
Mr. Reyes put out multiple videos on Facebook stating how he was out of town, couldn't collect signatures. He was so happy Miss Angelise Rosa could take care of him and take the reins, and how he was in DC. And yes, I have the videos if you'd like to see them.
So,
As far as that goes, that's not before us. That, again, you had a specific timeframe.
And I
a
also
specific
asked the
deadline.
board for a further.
Sir, I'm going to ask you to just stop you. I want to see if there's anything else from the commission. Any other commissioners?
I would just point out, Mr. Vice Chair, that on the nomination papers, the Board of Canvassers, it just indicates on the back the number of signatures.
Mhm.
That's all it has to do. So, you know,
you're
whether or not they have
stating that the
whether they have
document
that form
doesn't
number at the
reinforce-
top doesn't make any difference. It's the certification of the number of signatures that count.
I agree.
And there is a code number showing if the signature was accepted, not accepted, and the reason why.
There's a code, but not a candidate.
Commissioner Repose?
I agree with Commissioner Scholes that the signatures on the back, the numbers match the number on the sheet that they have collected minus the ones taken off.
So it's.
Well, from what I can see of this, and again, the commission can decide this any way they want. It appears to me your original objection was with regard to nomination paper 6. Nomination paper 6 was stricken. I don't believe that we can rule on these other nomination papers. I think most of that was informational for you and for everyone else here, frankly. I don't know if the commission has any other questions or a motion.
may I ask a question?
Well, I want to hear from the other
I
commissioners
apologize.
first, that's all. Any thoughts?
Well, see
I
what
just,
they have to
I
say.
just want to kind of clarify this and make it concise, probably more for myself, but the original objection that Mr. Fagnoli is looking for is, so he brought evidence about Form 6. Form 6 was stricken, but due to that, he wants all the forms signed by
That's correct.
the same collector to be stricken, which our legal counsel has advised us, the Supreme Court has ruled, we're not allowed to do that. Form 6 was stricken. Does that,
That's my understanding as
Mine
well.
too.
I don't know if
so I don't think that,
I understand too.
I would like to make a motion to reject the objection or the appeal based on those factors.
I
Second.
second it.
that's severally seconded. Any other discussion? All in favor signify by saying aye.
Aye.
Aye. The ayes have it. Good luck.
Thank you so much.
Thank you so much for your time today.
I believe the next matter is, matter of Anna Borges, Mayor of Pawtucket Independent. Yes. Are you Anna?
Yes.
Come on.
And is there anyone else here who wishes to be heard on the Borges matter?
Yes, I do have a witness.
Okay, we'll hold off, as a witness, we'll hold off just for the moment, sir. But no, by that I meant no other parties.
Would you identify yourself for the record, please?
My name is Anna Borges.
Okay, and would you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth before this body?
Yes.
Okay, thank you. I'll actually turn it over to our legal counsel first, just to give us some preliminary, and then you'll be free to say whatever you want.
Thank you.
Thank you, Mr. Vice Chair. I'll just, again, provide some legal framework on this matter. First, again, Ms. Borges, you'll have an opportunity to correct anything I say. I'm just going to summarize my understanding and my presentation of the law on point. I understand that Ms. Borges alleges that someone from the Pawtucket Board of Canvassers informed her that a person could register to vote and then immediately sign her nomination papers, and that she relied to her detriment on that understanding. As we know, under the law and even under the Constitution, a person must be registered to vote for at least 30 days before being eligible to vote. So we have that 30-day framework that exists presently. The question then becomes whether or not Ms. Borges can even rely upon a statement that's made by someone from the canvassing authority, assuming that it's true. So let's assume for a moment that it's true. Our Supreme Court has ruled that neither a government entity nor an agent of the government can modify, waive, or ignore applicable law through erroneous statements. And a person cannot rely upon the government's misstatements. And that's under the Romano decision, Romano versus Retirement Board of Employees System back in 2001. So even assuming that Ms. Borges were able to establish that someone from the agency, the Board of Canvassers or somewhere else within the municipality, made that representation to her, there's nothing that the board can do to modify that, and there's no remedy available to Ms. Borges when she relied upon that statement. It also appears that Ms. Borges cannot reach the minimum number of valid endorsement signatures under any factual scenario or under any remedy that we were to afford. The number of endorsement signatures required on nomination papers for a mayoral candidate are 200. The record would reflect, and Mr. Nunez can speak to this if needed, a total of 186 signatures were submitted. 124 were approved, 62 were disqualified. So even if all 186 were accepted, which is not the case, she still could not reach the minimum number needed of 200. And she can speak to this, I believe that she's challenging 2 signatures on the decision by the local board. So ultimately, since the board cannot change the outcome of this challenge by affording any remedy, the matter is again moot legally. And I believe that's all I have on this particular claim.
Ms. Borges?
Yes, I have something I would like to read. Members of the board, my name is Ana Helena Borges. I am an independent candidate for mayor of Pawtucket. I am here because the way the Pawtucket Board of Canvassers handled my nomination papers did not provide the orderly process your own regulation 410-RIC-R-20-00-10 is supposed to guarantee. Your rules say 2 critical things. First, in section 10.2, that these regulations exist to regulate the orderly process of gathering and certifying signatures submitted on nomination papers. Second, in section 10.4B, that a voter's signature must be accepted as valid if it can be reasonably identified as the voter's, and that ordinary variations in how someone signs are not by themselves grounds to throw out a signature. And section 10.6 requires that disputes over signatures be resolved based on evidence. Voter list records, registration cards, affidavits, and testimony, not on shifting explanations. What happened to my campaign in Pawtucket conflicts with each of those principles. From the beginning, I was pushed in the wrong direction. When I declared, no one at the Pawtucket office told me that endorsements were due the very next day, even though I had already spent months building relationships with businesses, medical partners, and community leaders who were prepared to stand with me. Instead of telling me about that deadline, the office focused entirely on signatures. You need 200 signatures. Try to get double and bring them in early so they can be counted. My attention was steered to raw signature counts and an implied earlier deadline, not the actual rules. I was then given advice about who could sign that directly contradicts section 10.6B1A. Staff told me that if a person was not registered, they could still sign my papers first if they register online or on a form, and that their signatures would count as long as the registration was filed. They even gave me voter registration forms to carry. Your rule assumes the opposite, that an endorser was an eligible voter at the time of signing the nomination paper. I followed the instructions I was given in good faith. The predictable result is what you see on my early sheets, a heavy pattern of signatures coded N for not registered, not found, not because I was careless, but because I was doing exactly what the local office told me to do. I was also told more than once that signatures would not count in the office if they could not read them, and that I needed to make sure people signed legibly. Arthur Wittenberg, who accompanied me and has submitted a sworn affidavit, heard this and warned me that if people changed the way they normally sign, their signatures might no longer match what is in the voter file and could later be used as a reason to reject them. That is exactly what Rule 10.4B is supposed to prevent. It instructs you to accept a signature when it can reasonably be identified as the voter, and says that ordinary variations are not by themselves grounds for invalidation. The local office pushed voters away from their natural signatures, then used that as a basis to throw out signatures. On top of this bad guidance came the filing day confusion that kept completed nomination sheets from ever reaching the office. I suffered a serious medical emergency on the filing day. Because of that, some of my completed forms were left at home. My immediate priority was to get medical help. Wanting to follow the rules, I called City Hall and found out what I could do. The mayor's recorded voice clearly said that City Hall was closed. That message matched what the woman at the Pawtucket office had told me earlier, that the office would close early on Friday at 12:30 p.m. Based on that combination of that in-person statement and the official phone recording, I reasonably believe there was no way to safely retrieve the remaining papers and get them accepted. Later that day, as my husband and I drove through downtown Pawtucket after addressing the medical emergency, we saw someone walking down City Hall steps and discovered that the building had in fact been open and taking nominational papers until 4:00 p.m., which happens to be the woman, Miss Rosa, who was here. I had never seen her prior to, I have not seen her afterwards. If she's here still, it would be great for her to come as a witness to tell you what I'm saying. She was the woman who was walking out of the building. Again, we saw her walking down City Hall steps and discovered that the building had in fact been open because she's the one who told us. And taking nomination papers until 4:00 p.m., she told us. From the street, City Hall looked closed. We have pictures. The only visible sign directed people to municipal court through the police station. Inside, the lights were off. and a staff member admitted that the mayor must have forgotten to change the message. Yet, even then, I was told that if I did not make it back to the office counter with the remaining stamped sheets before 4:00 p.m., they could not take them, no matter that I had been misled by their own recording while dealing with an emergency. At the subsequent hearing, this pattern was confirmed on video, recorded by Mr. Ford, who is here today, and I do have that if you'd like to see it. The chair of the Pawtucket Board, Miss Marie, began by acknowledging that I received some bad information from their office, not to some general confusion affecting everyone. When the committee asked who had told me the wrong closing time, I indicated the staff woman at the table who was there, who had given me that information. At first, she tried to distance herself. Are you saying I told you that? But when I replied, now you don't remember telling me that? She conceded, yes, I remember telling you that, and then tried to add that she also would have said that the office was open until 4 p.m. Whatever she's now trying to say, she would have said. The practical reality is that I relied on her actual words and the mayor's recorded message, both telling me City Hall was closed, and that is the only reason why some completed sheets did not reach the counter before 4 p.m. During that same hearing, a board member questioned whether I had any additional nomination papers I said I wanted to bring. In the video, you can hear his tone change. First, he demands, where are the papers you said you wanted to bring? And seems to expect that I did not have them. I immediately took them out of my bag and placed them on the table. Once he saw the forms, he did not say, if you had them, we could consider them. Instead, he shifted to, well, the time has passed and I can't see how our office can change that. You will have to appeal. In other words, the board moved from doubting the existence of my completed papers to admitting they existed, but refusing to consider them solely because of a filing deadline problem that grew out of the board's own bad information and the City Hall phone recording. An orderly process of gathering and certifying signatures does not look like this. It does not look like a city hall that appears closed, a phone system that tells candidates the building is closed, no public signage that nominations are being accepted, staff who misstate the closing time, and then a rigid stamp rule that takes no account of the misleading information the city itself put out. Despite all of this, I still brought you verifiable signatures. Voters, as you mentioned, there were 2 signatures there. Olace Freeman and Josh Wells are listed as active Pawtucket voters in the official citywide file. Mr. Wells signed as Josh Wells at his address in the presence of a witness under 10.4B. Those signatures should be accepted as long as they can reasonably be identified as those voters. And under 10.6B1, you can and should rely on the citywide voter list registration records and live testimony to correct the local board's errors. I have provided that evidence to you. I respectfully ask you to use your authority under 10.6D to call witnesses such as Mr. Wittenberg, the woman, Ms. Rosa, who I don't know if she's still here, to review the, and also review the City Hall phone recording and the local filing logs, and to examine Pat Ford's video of the hearing in which your own chair and staff member acknowledged that I received some bad information, and that the staff member did in fact tell me the wrong closing time. I also ask you to look at the photographs of City Hall's appearance on the filing day and the nomination sheets I produced from my bag at the hearing, which show that the signatures existed and were ready to be filed. Those documents will confirm that I relied on information that came directly from City Hall and the Pawtucket Board, and that I worked in good faith to comply. I am not asking you to bend the law for me. I am asking you to apply your own rules as they are written to count signatures of eligible voters that can reasonably be identified, to correct local mistakes using the evidence I have brought, and to recognize that a candidate is misled by official messages during a medical emergency should not be punished for failing to do the impossible. If you do that, I should be restored, and I should be allowed to continue my campaign so that the people of Pawtucket, not a confusing and misleading process, decide whether my name belongs on the ballot. And finally, allowing me to continue in the Pawtucket mayor's race doesn't change anything because I'm running as an independent. That is all. Thank you.
Perhaps for the record, we should just make sure that petitioners 1 can be marked as the documents that she filed with her appeal for us. And petitioners 2 would be the statement that you just read into the record, Ms. Borges, unless that, I know that you presented a statement in your petition, but is that separate? Is that a different narrative than what you said in your papers?
I'm sorry, sir. Can you please repeat the
Yeah,
question?
what you just read, was that part of your original submission to this board?
Where I went to appeal?
What you just read into the record just now?
Yes, what I just read into record just now.
Is,
it part of the package that you gave us?
Is it part of the package that I gave you? Yes, I believe so. I sent
it
information
seemed
to,
familiar, so then we can just have petitioners 1.
I sent information to
Yeah.
Mr. Nunes. He has everything
Okay.
that I'm talking
Okay.
about, affidavits, everything, the ballots, the sheets that never made it. He has everything. Yes.
Thank you.
So Ray, that's all one, you said?
That's all 1, yep.
And we have the record from the city as well?
The
Yes.
record's already been
We have the
submitted,
record.
so that can be petitioner, that can be exhibit. That'll be board 1, because that's not being presented by the petitioner, I assume.
That would be number 2. Number 1 would be an objection filed with us, which contains the statement she just read, and then exhibit number 2 would be the original filing with Pawtucket,
All right.
correct?
Yes, that's fine.
Is there anyone here from the city to address?
Good afternoon.
Could you identify yourself for the record?
Kenneth McGill, Registrar of the Board of Canvassers.
And I'm Lynn Fernandez, Senior Elections Clerk.
Would you both raise your right hands? You swear the testimony you give before this board to be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Go ahead.
I'm actually going to let my assistant talk because she's really the one that dealt with Ms. Borges. So if you have any questions, really, she's one that's going to answer them.
So I'm one of the staff
Can you make
members.
sure
I've
the
been,
microphone is near you?
I'm one of the staff members I've been at the city for 30 years now. As far as the hours that she says I told her we would be closing at 12:30, that's partial part of that conversation we had. She's ending it where I said City Hall closes at 12:30. I did say City Hall closes at 12:30 normally and followed the rest of the conversation with, but we would be open until 4 for candidates to come in and submit the nomination papers, like I told all the other candidates. I was the one that made all the notices all over City Hall. So we had these notices that tell everybody our office is open until 4, up to the 3rd floor,
And are those notices posted somewhere?
everywhere. Right where we're standing, we have a glass window right on the side of my face when I'm talking to people is the sign saying when they're due back.
Is this on
And-
your website as well?
I don't know if they're on the website, because I don't use the
Yeah,
website. But I mean, the nomination forms themselves say due back at 4. The paperwork on the window says 4. The door in our office, when you leave, says due back at 4. The door coming into my office says due back at 4. I had them on the elevators. I had them inside the elevators. I had them on the door leaving City Hall, entering City Hall. I have them everywhere. I've been doing this for years. So there was no mistake about me saying what time we close. And that's why when she said, "You told me," I said, "I told you?" Because I know that I never would have said that. And I said, well, I'm the one that made all the flyers. I know the hours of City Hall. So that's why I said, because 100%, I know that was not said. So these are all the flyers that we had up the whole time. So the hours it's ridiculous that somebody would say, I now have extra days to collect signatures. Anybody could come in the office and say, oh, you told me this, so now I get extra days. So I don't think that's right. We asked the other staff members who said you can collect registration cards, and nobody in the office has admitted or said they did. We've asked everybody. So as far as that goes, we don't know. I don't know.
One last thing. During the hearing at the Board of Canvassers, they were not presented with any papers. I was there, never saw it. To this date, we've never been given any extra papers, nomination papers. So even if we wanted to count them, we couldn't.
Well, from a legal standpoint, Ray, would they have been able to accept them anyway?
No, you would not have. I'm sure, as you understand.
But we do know also, if somebody does come, we watch that time clock and we stamp it to make sure it's exactly the right time. So if somebody does come in at 4:01, it still gets time stamped and brought in. We never turn anybody away for being past the deadline. The papers still would be time stamped and then brought to the board to say, hey, these papers came in past the deadline. We would never say, can't take them. That's not the rule. We know that. We all know that. So
Questions from commissioners?
Oh, I have a couple of questions.
Commissioner
First,
Schultz?
yes, first of all, does your office prepare the nomination papers for mayor?
we photocopy them,
Okay.
yes.
So if the candidate comes in and asks nomination papers to declare for candidacy, at that point, do you tell the candidate the time frame to submit these?
Oh, yes. As a matter of fact, I'm glad you brought that up. Because the other part of that conversation, whereas, and like I've been saying this to candidates for a long time because I've been there. We've had situations where like a newer candidate may go out and collect the signatures. And we say the due back, Friday, 4:00, deadline, whatever. And we've had someone bring in their papers 4:00. But now there's no time to go get more signatures, and now they're short signatures because they bring us a whole bunch of signatures, but they're not going to count, say, they're short signatures. There's no time to get more. When the papers come into our office, they get time stamped and they get put in the box in the order that they come in. So if you wait until the last day and bring your papers, they're going to be underneath a pile this high, and you're not going to have your answer as to how many good signatures you have. So I have suggested to people, like I would have, to say, well, they're due back on this day, but don't wait until the last day to bring in all your papers because they're going to go in the bottom of the box and you're not going to have a running figure of how many you need. So you don't have to wait until they're full. Just bring in sheets as you get them so you can have a running count of what you need. That's what we suggest to people. We're not saying bring them in Tuesday instead of Friday. By no means. We're saying bring papers as you get them so we can give you a number. We're trying to be helpful to people, not cancel somebody out of running. So it's kind of hurtful that somebody would say we were trying to shortchange them for getting signatures.
Okay, other than telling them about the time frame, do you provide them any information sheet as to timeframes?
Yeah, we give out the election calendar, how to run for office. We give out these flyers with their stuff to say, here's what your stuff's due back. We give all the stuff with the finance packet, with the election calendars. Mhm.
Any other questions? Comments?
Can I just add one thing? As far as the signatures go that were disqualified, my office has a person look through all the signatures, and if any come up no, right, a second person looks at them. So we double check all our signatures. So we're not just saying, no, this isn't a good signature.
And Director, our staff has, either yourself or our staff has reviewed the numbers, and those numbers that you post there where they were submitted, 186, those are correct?
Correct. And we also have the 2 signatures in question ready to be reviewed by the board if you choose to do so as well.
I have one question. When was the deadline? What date?
For the nomination papers?
Yes,
It was Friday,
Friday, July 10th at 4.
July
Yeah.
10th.
July 10th.
Okay, I see that Ms. Borges submitted some nomination papers on July 7th. And then one on, July 7th and July 8th, and 2 on the 10th. So even if she submitted on the 7th, you wouldn't have had a time to sort through and process the signatures by the 10th?
Yeah, no, as they come in, we take them from the box and
Okay.
check them. So yes, there would have been, people would have been checking.
So she would have known the number of signatures.
Wherever
on
they
or before
appeared in
the
that
10th,
box. By
right.
Wednesday, we probably had a few hundred sheets to check, I would imagine, by Wednesday.
Okay.
Yeah.
So Lynn, if I came in on the 10th to drop off my papers and I want to know how many signatures I've actually had approved, you could tell me that number?
No,
No.
you'd get an answer the next week, probably. Wednesday, the next week, probably. It'd be
Okay.
very.
You got to remember, we have until the following Thursday to look at all the signatures. So it's not like we give you an answer right away because we get hundreds to look at.
You're not gonna know if you would even have a chance to have enough signatures. That's why we say, bring sheets as you get them, because now somebody can grab your sheet and work on it, and you can call, or when we check them, I'll call the candidate and say, okay, you dropped off a sheet with 100, 60 of these are good, or this, so they know how many they're gonna get out there and find more.
So they would know.
Yeah, like we'll
Okay,
call them.
that was
or
my
they can go
question.
online and see.
That was my question.
Yeah, they can go online as we check them, but if it goes into the box and there's already 50 sheets ahead of you, it might
'Cause
take
you
you a
have a
couple days to
backlog.
get your answer. That's why I say, try to get it in quick so you can beat the pile.
And
Makes
as a
sense.
candidate, I believe you should keep track of what you've collected anyway, before you even turn it into you.
And they also get offered a free walking list. So I mean, the walking list will help you get good signatures. If you stand in front of
Mhm.
Stop and Shop, your signatures aren't gonna be any good.
Hmm.
So we try to help you get good signatures.
And you do.
Yeah, I mean,
Commissioner Hunt?
Question for Ms. Borges. The testimony regarding the instructional forms that are given out, did you receive those?
In answer to your question, mind you, we are all under oath here. When Miss Lynn Fernandez said that she posted everything, she was talking about inside the building. When you're outside the building, you can't see what's posted inside the building. And when she told me that City Hall closed Friday at 12:30, she never said, but we will be open until 4 p.m. to accept ballots. I am under oath. And I will also tell you this. I'm the founder and president of Bible Tea Time for Children. I serve a higher God, far higher than what we're doing here. And I have a pastor whose name is Pastor Cabral. And he's not here today, but I can give you his phone number if you'd like, and you can call him. And he's not going to lie either, for me or for anyone here. We serve a higher God. And he will tell you that I called him up to tell him, Pastor, it's too late. City Hall closed at 12:30. I can't get the rest of my ballots in. He will testify to that over the phone.
So, ma'am, my question was, did you receive the forms?
Your
The instructional
answer
forms.
to this is, I received the form, but the instructions of the Board of Canvassers supersedes the form. It doesn't matter what the form says. When they tell you, we close Friday at 12:30, that supersedes what the form says. It supersedes it. And when the mayor, Don Grebin, is on the recorded line before 12:30 and says, City Hall is closed, that supersedes. Therefore, the misinformation of the recorded line and the misinformation received by Ms. Lynn Fernandez, both that information supersedes anything that the form says. Also, when driving by at City Hall, I also noted there was no sign to say out front, nominations being accepted open till 4:00 p.m. Absolutely nothing. And everything was dark. And when we physically walked into the building, there was the woman sitting at the desk in the dark. So from the outside, it appeared City Hall is closed. I do have pictures to prove that. So absolutely not.
But, Ms. Borges, I take it you personally submitted the nomination papers to the Board of Canvassers on July 7th and on July 8th?
When I was there on July 8th,
Okay.
I did submit nomination papers, and I was told that
But
they didn't
excuse me.
have any nomination papers from the 8th, sir. But when they gave me copies, it said the 8th.
Right.
So there's a lot of discrepancies here. No,
But the-
I think, excuse me, let me just finish by saying this. Right behind you, it says, "The mission of the Board of Elections is to protect the integrity of the electoral process and to effectively and efficiently administer the provisions of the election law of the United States and the state of Rhode Island, including, but not limited to, the governance and conduct of elections, voter registration, campaign finance, public funding of campaigns, and any other duties described by law." The integrity has not been protected at all.
Okay,
So-
Ms. Borges, please.
Yes.
When you submitted those nomination papers, there were signs all over there saying the nomination papers, the deadline was at 4 p.m. on the 10th on July. Did you read those?
Sir, in
No,
all-
no, excuse me.
in all
Did
the-
you, no, did
Of
you read
course
those?
I read it, and
Okay.
I said to my witness,
And then,
whom I'd
excuse me,
like to come over,
excuse me.
there is a discrepancy.
When they told you City Hall was closed, didn't you question that? Didn't you say, look, I've been notified, little information sheet is, deadline is July 10th? Did you question that?
Sir, when a medical emergency coincided with that, my thinking is, I'm going to get these forms in. But when the medical emergency coincided with that, it changed things.
Okay, I understand that. Okay, but do you have other people working in your campaign that could have submitted the nomination papers on your behalf?
I have a witness here who can speak with you.
Did you have other people on your campaign? that
No,
could have
there was,
submitted-
would you want to explain that to me? I was told City Hall would close at 12:30. The recorded line said City Hall closed at 12:30. The outside of the building was dark. There were no signs posted to indicate differently. Is the woman still here?
Excuse me,
Frozen.
Mr.
Would you identify yourself for the record, please?
Arthur Wittenberg, for the record.
Okay, would you raise your right hand? You swear to tell the truth before this body, so help you God?
I do, every word.
Okay.
I understand your line of questioning, and your line of question is going to be pointed directly to a time frame that's posted, and that's fine. Signs are posted all throughout City Hall inside the building. So that's okay. It's like the attorney, and he's going to give the summation of the law. The law is black and white, but there are gray areas as well. And sometimes we have to
Sir,
mention.
but you're here as a witness?
No,
No, you're
I'm
making
here as
argument.
both. I'm here to help her
And then she told you guys. I was
I'm not going to accept argument on her behalf because you're not her attorney, correct?
I'm her attorney, in fact.
He's my witness.
If you're here as a witness, then you need to testify to facts
Yep, you got it.
associated with this, not give us a discussion on what the law should do or shouldn't do.
Well, that's
So
up to you.
I need you to speak to the facts. I believe she's offering your testimony for what happened on Friday, the
No,
10th.
not just Friday, every day. I'm with her every day, going into dropping off ballots and everything else. I heard multiple times, well, I'm not gonna say multiple times, delivering the forms to them, they would always caution her on signatures. They told her, make sure when your people sign, when they sign the ballot, they sign it legibly so we can see it.
Mhm.
Because if we can't read it, we can't give you proper credit
Okay.
for it. When we left, I told her I wouldn't follow that instruction. And the reason I wouldn't follow
Okay,
that,
I don't need to
you're
hear
asking me
what
to
you.
testify.
Sir, I
I'm
don't need,
testifying.
I'm not asking you to testify. She's asking you to testify. I can't simply let you sit here and narrate. What,
What
Ms.
is the
Borges,
narration?
what are you offering his testimony for?
I'm offering his testimony of what I said, that the City Hall recording said that they closed at 12:30, they were closed, that I was told that the office closes at 12:30 on Friday, and that there was nothing posted outside of City Hall indicating you could, 4 PM, ballots coming in, that sort of thing. Nothing, and it was, if there was something on the door, no, with glass, you could, far away and in the dark. And one of the employees inside again said, oh, Don Greben forgot, or, to change the message.
So those are the facts that you can testify to. So give me whatever testimony you have on those 4 issues that she just mentioned.
And he was with me when I had the medical emergency.
Okay.
And so with City Hall closing at 12:30, I didn't say to him, why don't you go home and get those ballots we have and get those, no, it wasn't going to happen. It wasn't going to happen.
On that particular day, she had the medical
sorry.
emergency. I can speak loud enough. They can.
No, we need the microphone for recording. Thank you so much.
On that particular day, since you're limiting me to that day when I witnessed the entire event, but I'll stick to just that day. On that day, she was injured. We brought her to the hospital so she can be seen. She was saying, well, I've already called to confirm, and then she called again so I can hear the message. It indeed said that City Hall was closed. The skeptical person was me. I don't like politics. I never did. So I told her, that's why I said I wouldn't trust that 12:30 thing. I would stick with the 4 o'clock time frame because that's what they said. I can run back, go get these ballots and try to drop everything off. Well, it's really no need to, and she let me hear the recording. So when I heard the recording actually said City Hall is now closed. Okay, well, that put me to rest because I'm the skeptic. So, okay, I didn't go get it. So when we're driving back, we're coming back, and that's when we saw Miss Rose coming out of City Hall, and it was 3:30, about 3:30, 3:40, somewhere in that neighborhood. And she was coming out. So we went to speak with her, and we were telling her then, well, we were told the City Hall was closed at 12:30. So she said, no, they're in there taking ballots right now. Well, we do have a few ballots that's in the vehicle right now. All right, then let's get these, bring them in, and then we'll explain to them what was going on.
Okay.
Because since they're here, we can at least let them know and try to get back to get the papers and come back. So it was impossible to get back and then get to the house and then get back to them with the nomination papers. At the hearing, am I allowed to, because I was there, am I allowed to speak on that?
Mhm.
Okay, so after objection hearing, the lady started the hearing off, and Mr. Pat Ford, he's recorded the whole thing, so you can hear the recording yourself. She said you've been given some bad information by the board, and when she pointed her out,
That's when she said, well, I would have told you. Well, would have told you, and I definitely did not tell you that, are two different animals. I don't care what stall you put them in. So she didn't say what she said. She said, because I was there when the statement was being made. That's why I put it in an affidavit.
Were you at City Hall on days prior to that?
I was at City Hall. That's what I told you. I was there every day. They told her she didn't turn anything on the 8th. When I know we were there turning in papers on the 8th. But when we get copies, there's only one sheet from the 8th. But we were told you didn't turn anything in on the 8th. So that's a little suspicious. I told you, I'm the skeptic. So that's a little suspicious to me.
Did you see any of the posted signs when you were there at City Hall?
I saw it upstairs on the door that they'll be open. That's why I said, I was the one who was saying I wouldn't trust it. I would still get over there. But when she played the recording for me, that City Hall is definitely closed. And I said, well, I guess they were right. I guess they wouldn't know they worked there. And any reasonable person would have said, I guess they know because they work there. So to make a statement, and it's called premise liability, when you can sue someone under if it's a school. If a teacher did something wrong, you can sue the school because the school is supposed to be protecting your child. It's called premise liability. So if an employee tell me something and struck me wrong, in law, I can sue him under that. And I would be victorious.
Okay.
Just so we'll know.
Any questions from the commission?
So on the exterior of all your doors, did you have a sign posted that you could see from the outside side?
What does this sign read?
I can't read it from
I know
there.
you can't. And neither can we.
Well, but I can't read it from there because I don't have my glasses
Can't
on.
see it now.
Sir,
Nobody will see that from the
But
street.
it was
sir,
on the glass.
you're here
Can
as
you
a
read
witness.
it to us? Can you read it to us, what it just
Yes,
says?
It says Board of Canvas office will be open until 4 PM today to accept nomination papers, 3rd floor. But there's no, City Hall
Okay.
closes at 12:30 on
Correct.
Fridays. But one of the things that I have said to people who work there, there's no sign, nothing on the sidewalk of City Hall saying City Hall's closed. So most people think City Hall's open. And they park their car, they walk across the street, and they try to open the doors, and they're like, City Hall's closed. There's nothing to tell you it's closed. So we don't have a sign on the sidewalk saying, hey, it's open today. It usually is open. Most people don't know it's closed. So you would walk across the street like everybody else and try to open the door and see the sign saying, hey, come on in. But you wouldn't be trying to read this sign from across the street.
No, you'd be
You
going
would
up
have
the
came to City
sidewalk.
Hall knowing it's
That's true,
open.
right, because your parking is quite a ways away.
Yeah.
I have another question, if I
Oh,
could.
okay.
Absolutely.
So if I were to call, does it just tell me that City Hall is closed at 12:30 on Friday, July such and such a date? Does it give me the options that I could then proceed to be connected to your office?
Yeah, I guess. And they should have probably changed the message saying
Board of
today it's
Canvases
open, but
was
no.
open,
I mean, nobody thought of that, I guess. The
That's why I was
regular answer
wondering.
machine was in fact just reading what it always reads, that
Right,
City Hall's office hours are
And that's why I
open
was
late these days.
wondering,
If you need assistance, direct call our department.
and that's why I had the
Mhm.
question, would it allow you to
Yes.
proceed?
Yes, you could have called our office.
No, not at all.
Commissioner Connors?
I think the fact that you may or may not, and this is directed to Ms. Borges, you may or may not have received inaccurate information doesn't supersede accurate information. And I think I'd like to have our legal counsel restate what you said at the beginning, where the courts spoke to that.
Sir, please shut that off or I'm gonna have you removed.
You can remove,
You can give it to me and
but I'm
I'll
gonna give
play
her
it.
this. This is the recording.
Is that recording part of the
It's all
record?
part of the evidence.
I don't know.
It's part of the evidence.
Okay. Yeah, so there's the doctrine of reliance upon a misrepresentation. When a state agent makes a misrepresentation of what the law is, for better or worse, the person receiving that information cannot rely upon it. Every one of us is expected to comply with the law, and if a state agent fails to give you accurate summary of the law, it doesn't change that responsibility of the person who's subject to the law. Does that help?
Absolutely. I mean, that sums it up to me, that clarifies it. And that's assuming the candidate received bad information. We don't know whether she did or not, because she did receive some accurate information. She may have received some inaccurate information. However, it's incumbent upon the candidate themselves to ferret out what the regulations are. So unfortunately, you had a medical emergency that kind of threw things off, and I'm sorry to hear that. But the fact is, you didn't get your signatures or enough signatures in time. And I think, that the appeal, to me, should be rejected.
I agree.
Is that a motion?
I'll make it as a motion.
I'll second it.
There's a motion and a second. Any discussion from the commissioners?
I would just say that everyone's presumed to know the law. And if someone's running for your office, if they see misinformation, they should challenge that and look at the
I will
requirements.
challenge
The
this.
statute says 4 o'clock, that was the requirement. If somebody says, gives bad misinformation, that is, that cannot be relied upon, misinformation. So for that, I support this motion.
I wanted to make a quick comment to the Board of Canvassers, if it's possible, to amend the call, like the message that comes up. And as someone who, I appreciate the sign, I think it's important. One, I hope it was also in both languages. And 3, I guess for next year, maybe we can make sure that it's a bigger sign and this, so that things like this can't happen. That would be my only comment. Great.
Well,
That's my only comment.
It is saying that I did not say we would close at 12:30 and not accepting nomination papers until 4. I think there's a possibility that she believes I said that, because maybe the second part of my conversation was not heard. Sometimes things get cut off in the middle of a conversation, and maybe the second part was not heard.
Great.
But,
Thank you.
So where do I appeal from
Okay,
here?
hold on.
Wait,
Okay.
Anything else from the commissioners? Then we'll take a vote. All in favor of Commissioner Connor's motion?
Aye.
Say aye.
Aye.
Any opposed? The ayes have it. Motion carries. The objection is dismissed.
Where do I appeal from here? Where do I go from here?
I can't give you legal advice, ma'am. I'm sorry.
Okay, well, I object and I appeal, and you will all see me again. And we will make this right for all candidates.
Okay.
It will be fair,
Ma'am, I'm going to ask you to.
and the election needs
Ma'am,
to
I'm
be
going to ask you to
protected.
take whatever legal response you have and to do that, but there are other people here that are also waiting to be heard.
Thank
okay.
you kindly.
The next matter on the agenda is Arlette Hidalgo, State Representative, District 12, Democrat.
Will all of the parties come forward who are involved in this case? And could everybody, starting to my left here, identify themselves?
Thank you, counsel.
Hello, my name is Arlette Hidalgo.
Good afternoon, Nelson Robles. I am the attorney for Ms. Hidalgo.
Good afternoon. My name is Hamlet, and I'm representing Carlos Daniels on this matter. Thank you.
I didn't catch your last name. Your last name is?
Lopez.
Hamlet Lopez, okay.
And board members, just so I'm clear, representing, I just want to know the capacity, is it?
That will be something we're going to be talking
Okay,
about, at
thank
least initially,
Hmm.
if we're ready. So-
Again, I'll turn this over to legal counsel to start the process.
I'll be very brief, Mr. Vice Chair. I'm just going to focus my brief comments on standing, and I'm here to see if I have misunderstood who has brought what and who's brought what appeal. Um, um, An appeal was filed by you, sir, right, Mr. Lopez?
Yes, sir.
From a Providence Board of Canvassers decision. And that decision arose from a complaint that was made by a Joseph S. Almeida or a Joseph S. Almeida Jr., is that right?
Yes,
Okay. And he made a request for a residency review concerning the residence of the candidate in question, right?
correct.
All right. Now, Mr. Almeida has not brought the appeal. I've seen nothing in the record to show that he is the one who brought the appeal. It's been brought by Mr. Lopez. In my understanding, and correct me if I'm wrong, is that you are, and I think you stated this, you're a resident of the city of East Providence.
Mhm.
You have no right to vote for State Representative District 12, right?
Correct.
So our Supreme Court has addressed the question of standing, and I should just break it down briefly because we've had a little bit of differences on how we recognize standing here. When standing is brought on a straight challenge to a signature, there are people who can bring it either as the candidate, party chair, or even a person who has written authorization from that candidate. That is specifically for challenges to the signatures that are on nomination papers. There is a broader recognition for standing on the eligibility of a candidate. So if someone is challenging the person's ability to even run, saying they're a convicted felon, saying they're not a resident, saying any number of things, so they're legally not eligible to run, our courts have given a much broader, more generous recognition of standing. But even in that case, and this goes back to our Supreme Court cases, what they've always looked for is, so long as you are an elector, someone who can vote in the election in question, you shall be seen as having standing. Here, under no circumstances can the appellant satisfy that because he is a resident of the city of East Providence, not of Providence. So I believe that the matter should be dismissed because the appeal is not before you properly. It should only have been brought by either the complainant, Mr. Almeida, or a recognized attorney on his behalf.
Mr. Almeida's here.
But Mr. Almeida, I did not know you're here, but you didn't file any appeal.
By the rules that was given me at City Hall, and that's why we signed the
Right.
paper. Mr. Evans is just explaining our complaint.
Correct.
Not as an attorney, he's here
No.
as a other person. That is a problem with respect to standing, Mr. Almeida. That's the
The campaign
problem.
manager wouldn't count in this matter. I mean, I had the sign authorization, but Joe's here, and we filed them together when we were there.
If Mr. Almeida has filed the appeal, this would not even be a question. He's nowhere to be found on the appeal. It's just by somebody who's not a resident of that district who's now challenging the eligibility of a candidate from District 12. So I don't see a basis for even hearing the appeal itself. Before you even reach the merits of what Providence did, there's really nothing here for you to review because without an appeal, there's no jurisdiction for the board.
You go back to the city of Providence and ask them, but we're here on the conditions for the candidate. That's
Sir, you're not even here to address the board. You're just yelling from the back of the room. I'm gonna ask you to be quiet while we take our advice of legal counsel, listen to what he says, and then I get to ask the board members what their feeling is on this matter. So based upon what our legal counsel has said, is there any discussion from the board members or any questions from the board members?
Unless Mr. Lopez says he's a resident of the district, I don't see how we can consider his rejection.
And Mr. Lopez, in your papers, you indicate you're a resident of East Providence. Is that correct?
Right in my license, yeah. I'm actually staying in the district, helping Mr. Cedeno in the campaign currently, but that's what my license says. I go by my license.
I'm going to ask you to raise your right hand just for a second. You swear that the testimony before this body is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Are you a voter in the city of Providence?
No,
Thank you.
my whole thing is,
Based on what council has told me, are you a voter in District 12?
no, but Joe's here, so when we appealed
No,
it,
that-
he was
that's-
here and nothing was said whether or not I could have challenged. I think it was a little bit late, but we were here and I think something could have been said like, all right, look, Joe's here. I mean, Joe, you would have to do it since you live in a district. You know, I just did it. Joe, as you can see, he has a can, you know, I was like, look, I'll just sign it and go ahead. We're working on this together. But we were both here when we presented it. And
So what was the decision of you being your name rather than
We
Mr.
were-
Almeida?
no, we were both here working on it. It was kind of like late and the door was kind of like, you know, heavy and all that stuff. When we tried to go in, they were great enough to kind of like let us go in. But we were both here and we both had the paperwork. I just decided just to sign it because we were both working on it. But nothing was said whether or not you had to live in a district. But Joe lives in a district, you know, and he's here with us today.
Yeah, I don't know what the board's feeling is on this, but.
You just have to follow the rules as presented by the Supreme Court.
I mean,
Question standing is a big important issue here.
I agree. Couldn't agree more. And I think council's been quite clear on it.
Right, it's funny because the matter we're presenting here is the same matter I couldn't, speak on his issue, which we want, a fair elections, want to make sure that voters in that district, right, have a chance to have a candidate that lives in the district. And it's sad, right, because at the end of the day, we just going out there as our, civic duty to kind of participate and make sure that these elections are fair for everyone, especially in District 12. But she had the same issue as me, but she went from Cranston
Okay.
to another address.
Okay,
to
well,
another
I'm
address.
gonna actually stop you now. I'm gonna hear from council.
And board members, I will say, the Board of Canvassers has heard this case at their level, though there's no standing here to hear this case, and I would request, yes,
I was gonna ask if you had a motion.
yes, I would move to dismiss whatever objections the complainant had.
Is the board, is there a motion from the board? There's a motion and a second. Any discussion from the board? All in favor signify by saying aye. Aye. The ayes have it.
Thank
board
you.
members.
Okay. Item number 2. I believe that concludes all of the objections. Director.
That is correct, yes.
Item number 2, the board may discuss and vote to approve the polling locations and early voting locations for the statewide primary to be held on September 9, 2026. And I will turn it over to the executive director.
Honorable members of the board, the staff has worked closely with our local boards of canvassers on the selection of the 358 polling locations to be used for the statewide primary to be held on September 9th, 2026. This number does include 6 polling locations that the town of Lincoln is planning to open. However, the previous submissions by the town of Lincoln to the staff had some improper combinations on at least 2 occasions, and they were unable to meet in order to correct their submission. They're unable to meet until Monday, July 27th. So this board will need to approve Lincoln's polling place submissions at a future meeting, ideally next week. Beginning in May, the staff began to notify the boards of canvassers of the criteria for them to begin selecting their polling locations for this upcoming primary. This includes the fact that under Rhode Island General Law 1711-1, taking into consideration accessibility, proximity to dense concentrations of voters within their communities, public transportation, and equitable distribution across the city or town. Because this is a primary, Rhode Island General Law 1711-1 also allows the local boards to combine their polling locations with the approval of this board. The law allows the boards to seek combination of polling places beyond the normal 3,500 voter cap based on the fact that turnout is historically, as you know, lower in these primaries, even the statewide primary. Many local boards are seeking to combine due to the fact that turnout is expected to be low because many cities and towns actually have no local contests. Also, only 6 of the 38 Senate races are contested this primary, and 15 of the 75 House seats are contested this year. Combining locations also allows our local boards to use fewer municipal resources and operate more efficiently on primary day. 19 local boards of the 39 have requested to combine locations, and that includes Lincoln's pending request. All of these requests are based on a unanimous vote of the local board as required under that same statute 1711-1. Now, as you can see on the chart I've displayed on the screen here, turnout for September primaries in gubernatorial election years since 2014 has run as low as 17% in 2022 to as high as 22% in 2014, prior to early voting existing. The state has opened as few as 260 polling locations in 2022 and up to 386 polling locations in 2014, back when the state had 20% more polling locations overall across the state. Now, in recent years, as you know, you're well aware, voters have been shifting their activity for casting their ballot to the 20-day early voting period and the mail ballot process. This leaves fewer voters to actually show up on election day. And as you recall, in 2016, we began deploying electronic poll books that made polls more efficient. 2018, we began allocating more voting machines to precincts with higher number of eligible votes, multiple page ballots, particularly in the bilingual communities. The board has also increased our inventory of voting booths and began allocating more voting equipment to locations that could use them. This combination of measures has allowed each polling place to process a higher volume of voters for less disruption, reducing lines for either the check-in process, casting a ballot into the tabulator, etc. Now, for example, in this proposal before you, even if we project for a 30% turnout, which would be higher than everything that you see on the screen there since 2014, with 50% of voters actually turning out at the polls and the remainder voting early or voting by mail, that would mean that our largest precinct, which would be 3505, which would be Westerly Middle School, would only be expected to process around 1,800 voters on September 9th, which is well below the current 3,500 maximum voters allowed by state law. Any location which could potentially process over 1,000 voters will receive at least 2 DS200 voting machines from our facility. And they will also receive additional poll pads to efficiently process these voters. And we also require these local boards to hire additional poll workers for these higher volume locations, and we will deploy the equipment where needed. All of the locations before you have been reviewed by the local board of canvassers and our staff to ensure that the facilities can properly handle the anticipated flow of voters outside and inside these facilities. Now, for early voting, the typical 39 early voting locations will be in operation between August 20th and September 8th. For the primary, 8 of these locations will be located in a building other than city or town hall. This is up from the 4 off-site locations that were opened in 2024. Now, we expect to continue to see this trend as early voting continues to increase in popularity, and the board has begun to regulate early voting more like polling locations on election day. These local boards understand that city or town halls are just not physically large enough or accessible enough to efficiently handle the volume they are currently seeing throughout early voting. Therefore, they are moving early voting to facilities that are better suited. Please note we did receive an emailed complaint, which you should have before you, from a voter in Westerly with concerns about the Westerly Police Station being used as the early voting location. The Westerly Board of Canvassers is also planning on holding early voting in a polling location at the police station in the general election, which I know is not the subject of today, but that is their plan for the general election. The local board previously had used, and correct me if I'm wrong because they are here, the library on an upper level in Town Hall. in the 2024 election. However, based on what my conversations with the local board, there were lines of voters that extended into stairwells and disrupted the use of the elevator within the facility. However, more importantly, the building, the city hall, town hall, excuse me, no longer meets the minimum dimension requirements required by the early voting regulation that was recently passed by the board. Now, the board was unable to find another suitable facility. Now, the police station is a town building, according to the board, has enough space to conduct early voting efficiently, and it meets the requirements of the regulation. They are also planning on using it as a polling location in November, because the previous polling location is a banquet hall that had inconsistent availability, and the electronic poll pads that the board has sent for operation there consistently had trouble obtaining wireless signal in past elections. Those were the reasons given by the local board. Representatives from the Westerly Board of Canvassers are here today to answer any additional questions that the board may have. I just felt I wanted to pass that emailed complaint that we did receive over from that voter, and I did forward that complaint to the local Board of Canvassers and ask them to be here today to answer any questions. Now, remember, as usual, local boards on primary day, September 9th, they will still post a notice at any default polling location which is not opening that day. That notice will direct voters to their proper polling location. Vote.ri.gov will also be updated for voters to look up their assigned polling locations before the primary. And additionally, under Rhode Island General Law 1711-1-1, local boards must advertise these combinations in the newspaper at least 7 days prior to September 9th. Now, based on the information provided to you today by the staff, we do agree with these 352 polling locations, because I'm not including Lincoln in that total number yet, and these early voting locations for the September 9th, 2026 statewide primary, and we do request that you approve them.
Questions from the commission?
It is currently, yes, but if you have any questions about its use, we do have the local board here.
Before we get to that, I just want to ask, Miguel, did the staff have a chance to visit that site, the Westerly Police Station?
Yes, we visit every polling location and every early voting location for inspection.
So I noticed that it says community room. I know, I've never been to the Westerly Police Station, but I know in some police stations, I can speak to Cumberland, if you walk in, there's no, if you want to deal with the police, you have to continue down the hallway and speak to a receptionist for the police. There's also a community room right when you walk in off to your left. So that it's almost like the community room is separated from the police. So I don't know if the staff had a chance to kind of look at the layout, if that would play into this complaint.
I do have staff that can answer to that, but I think Westerly can also answer to that as well. I didn't personally inspect the room, but either the Westerly Board of Canvass, I think, can answer that question for you.
I can speak, I have seen that room in the past.
Is it right when you come in?
It is, the former police chief is here, who is now the town manager, but I do have to say that based on my experience of early voting at the town hall versus the police station is definitely a better facility due to parking and accessibility. And it also is a better facility to replace the Venice restaurant. But the former police chief is here, as is the town clerk, who I'm sure can speak to the location within the building.
Sure, why don't you come right up?
Good afternoon. Sean Lacy, I'm the town manager, and as he indicated, I was a former chief. So it is, just as you stated, it's a community room that's not, it's in the same facility, but it's separate. It's got separate bathrooms, it's separate. You don't go through the police department to get to it. You go through the foyer, and it's a community room off to the side. It's used for all types of different events that we host.
It's actually a pretty nice place. It's a new building.
So my question is, that's the best available facility you have for early voting?
Yes, it's a newer facility. It was built in the 2008. All ADA accessible. It's a big community room, so
It's all on the first floor.
all on the first floor.
Accessible.
That's correct. Handicap accessible bathrooms, plenty of parking.
And you're going to have signage presumably?
Absolutely.
And I think the community room's rather large.
It's a large room. I'm guessing it's probably in the 600-700 square foot range.
So at this moment, there's no sort of thoughts about moving at this moment.
No, there is not.
I don't think there's anything large enough to be a polling location in 3604 in that district.
I agree.
I think the complaint spoke to voters possibly being intimidated with the presence of police at the polling place. So if you could speak to where generally, obviously, a police officer could be walking in and out the front doors, but generally speaking, where in the building are police officers positioned in regards to the community room?
Yeah, so the community room, when you're looking at the front of the building, is to the right. The police department is the main facility. The general police would not interact anything with this room. They don't walk by it. They don't.
walk by the entrance at all.
No. If somebody was to come into the front lobby of the police department to file, a report or some sort of complaint, the police officer would come out to the lobby to talk to them to take whatever the complaint is. So the foyer area, yes, it's off the foyer. You go through another entrance area to go to the community room, but it's not in any of the day-to-day interaction. All the police enter and exit the building, cruisers, all the equipment is through the rear parking lot, nothing to do with the front of the facility.
Any other questions?
I would like to make a motion that we approve Miguel's presentation and the use of the Westlake Police Station as early voting in a polling place. But I want to thank Miguel. You did a great job on this, explaining what is going to happen. I have a question. How many moving companies are we going to be using this year to move the voting equipment to and from?
3.
Again, I make a motion.
Is there a
that-
second to Commissioner Reposo's? There's a motion and a second. Any discussion? I just have one brief item of discussion. I have a bit of a concern with the email. The email indicates, I guess at the beginning of the email, I'm forwarding the attached notice regarding a change in polling place location. Given the history of concerns around law enforcement present affecting voter conduct and turnout, I don't think that's ever been an issue in the state of Rhode Island. I know it's never been an issue in the city or town of Westerly. It's never been an issue in my town. In fact, we've had to have a police presence to mandate the area, clear the area for the voters, if anything. So I would support Commissioner Reposo's motion wholeheartedly, and that's basically all I have to say. Any, since it's a motion and a second, all in favor signify by saying aye.
Aye.
The ayes have it. Any opposed? Motion carries. Is there, I believe that's it.
That's it.
Is there a motion to adjourn?
Adjourn. The motion to adjourn.
Second.
Motion and a second. All in favor signify by saying aye.
It's just
Aye.
time to go.
The ayes have it.